Good afternoon and welcome to another edition of our weekly Facebook Live series where we have answers to a lot of the questions that we've received in our office on questions related to family law, bankruptcy law, immigration, and criminal law. We've also advised a lot of clients in the areas of tax and also criminal, so stay tuned for when we have topics related to those issues. My name is Jennifer Hunt and I'm one of the founding partners of JLG Law Group. We're located in Salt Lake City, Utah, and we've been privileged enough to serve clients all around the state of Utah and also from around the world and across the nation in areas of immigration. So if you're viewing this episode here today and you have any questions that you'd like us to answer on our next show, please send us a message on our Facebook page, or also you can contact us at 801-883-8204 and we'd be happy to set up a consultation with you. Also, if you are interested in learning more about our clients' experiences with JLJ Law Group, please log on to Google and take a look at many of the Google reviews that we have. You'll see that we have many satisfied clients that have left us glowing reviews, and so that will give you a little bit of insight about the quality services that we provide to our clients. The issue that I'd like to discuss today is related to family law. In particular, I'd like to go over the steps of what it would take to file a divorce in Utah. Now, understand that divorce law is state specific, and so the information that I provide to you here today is general information. Please consult with an attorney in your state if you are currently not residing in the state of Utah, so that that attorney can provide you with information that you need that is more specific to your state's laws and guidelines with respect to child support, alimony, or property division matters. Again, the information I'm going over here today is general information and it's specific to the state of Utah. So a lot of people, when they come into my office, usually they're it's a very traumatic experience to go through a divorce. And so I think that having a lot of the information as to what the process looks like before you start will help you in making the decision as to whether or not you want to proceed with this process. In order to initiate a divorce, first off, you will need to file a complaint with the court that is located in the county where you reside. In the state of Utah, there is a residency requirement that is required of individuals that filed for divorce. You have to have lived in Utah at least 3 months for the state of Utah to have jurisdiction over your case, and you also need to reside in the county where you intend to initiate the divorce proceedings. After you file the divorce, then the next step is to serve the other party with a copy of your complaint. It's mandatory that you establish the fact that you are initiating the divorce proceedings. Any type of action cannot be commenced until you have established that the other person has received the legal papers. This is generally done through personal service, through a constable or a sheriff's office. They will then file an affidavit with the court verifying that the other individual has received the divorce papers. Once that person receives the divorce pleadings, they generally have 21 days to answer your complaint. If they are out of state, then they have 30 days to answer the complaint. If your spouse does not answer the complaint, then you can obtain a default against them. What that means is a default allows the judge to enter a final divorce order and decree with whatever demands that you have put in your original complaint. In Utah, from start to finish, default divorce proceedings will generally take you about 90 days. It's difficult to get a divorce finalized before the 90-day period unless there are extenuating circumstances. Generally, this would include filing documentation showing that the parties have been separated for an extended period of time, or in situations where the parties have experienced domestic violence. Those are the rare circumstances in which the court will expedite a divorce proceeding. But if you are unable to establish that, then in most situations the court will require a 90-day waiting period. And this makes sense if you think about it in terms of the way divorce proceedings take place. I've had a lot of people who have come into my office where they have initiated divorce proceedings and then subsequently changed their minds. People reconcile, there's change in circumstances. For whatever reason, the divorce does not proceed through as planned. And so it does make sense that the court would make you wait 90 days to ensure that you have really finalized your decision before the court enters its final divorce decree. Now, that's in the circumstance of a situation where somebody has not answered your divorce complaint. So let's go over the situation where the other party does file an answer, meaning that they have filed an answer disputing what you have demanded in your original divorce complaint. So in that circumstance, the next step to go to mediation. In Utah, it's mandatory that all parties engage in mediation before proceeding to trial. A lot of people are unclear as to what this entails, this mediation requirement. Mediation is where you and your spouse would meet with a third party, a neutral third party. Usually they're certified in domestic matters, or they are retired judges. And the both of you will sit there and try to hash out a resolution to your case. We will go over issues related to child custody, issues related to property division, who pays what debts, who's responsible for the care and transport of the children, tax returns. All issues that may be dispute will be discussed at the mediation. It's not mandatory that you actually reach a resolution at the mediation, but the court does require that you actually go through the exercise of trying to mediate. However, the vast majority of divorce cases are settled at mediation, and a very few number of them actually ever go on to trial. In the event that you are not able to resolve all of your issues at mediation, then the next step is to prepare the issue for trial. Now, trial is a lot like what you have seen maybe on television. Both parties will have an opportunity to present their case, and this will include testimony from key witnesses, exhibits related to the financials of the party's marriage, assets, exhibits related to assets. So then the judge can make a decision as to who should get custody of the party's minor children, who should be responsible for the party's debts, and who's entitled to what portion of the party's assets at the end of the marriage. Now, if you are in the process of contemplating a divorce, one of the things that I would recommend that you do right now is start pulling together all of your financial assets so that you have a better understanding of what household items your family has. The vast majority of people, when they come into my office, unfortunately, are not well aware of the type of assets and liabilities that their family has, because in some situations either the husband or the wife has taken on the bulk of the responsibility for managing those issues. And so if you are not prepared, or if you do not have a full comprehension of what your family's finances look like, then it could make it difficult for you to fully obtain your rightful share of those assets. One issue that I want to discuss is the issue of temporary orders. Those are basically the rules that govern a divorce while it's pending. We all know that some divorces can take a long time to finalize, and so there still needs to be a set of guidelines to help the parties engage in a respectful manner with one another, particularly when it comes to issues of child support and child custody. And so oftentimes the court will enter temporary orders so that the parties have rules in place to minimize the conflict that could take place when there are custody and parent and joint custody arrangements, or child transport issues that come into play in these cases. So that's something to take into consideration. The other thing that temporary orders set up is they also set up issues pertaining to financial support for one of the spouses, or the payment of attorney fees. So if you're in a situation where you feel as though one of the parties, maybe your spouse has been the primary breadwinner, and you lack the financial resources to proceed with a divorce, don't be too concerned with that issue, because temporary orders may be entered by the court so that your ex-spouse could assist you with the expenses of filing for a divorce. The court is well aware that this is a dynamic that is fairly common, particularly in the state of Utah, where one person is the primary breadwinner and the other person has stayed home and managed the household, or has been the primary caretaker for the party's children. So there are situations where the court could help you obtain financial relief from the other party so that you are fairly represented in the proceedings, and so that you have the legal assistance that you need in order to represent yourself in these cases. So keep that in mind as you contemplate these matters. The other issue that unfortunately comes up in our cases is the issue of disputes related to the custody of minor children. Unfortunately, when there are minor children involved in a divorce case, the case often becomes a lot more conflicted, and there are a lot of situations where it's difficult for the court to make a decision as to who should be entitled to custody of the minor children. In these circumstances, if there has been an allegation of abuse, then the court will appoint somebody called a guardian ad litem, who is a special attorney designated to represent the interests of the children. They stand in as a more neutral party to ensure that the children are protected and that they are placed in the home that would provide best for their growth and developmental needs. In situations where there has not been a guardian ad litem appointed, the court may also request, and the parties may choose to elect to use, what's called a custody evaluator. Custody evaluators are independent people who will go in and interview the children, interview both of the parents, and then make recommendations to the court. So those are additional expenses that the parties may incur if they are unable to reach a resolution in their case. So hopefully, with the tidbit of information that I've been able to provide you here today, it assists you in your decision making. If you are contemplating a divorce, we do provide free legal consultations on these matters, so please feel free to contact our office anytime you need to obtain more information on this, or send me a private message and I will be more than happy to answer any of your questions or concerns. Again, we do this series every week on Wednesday at noon Mountain Standard Time, and we'd be happy to answer any of your questions online if you send us a message. So thank you for tuning in. We look forward to hearing from you, and hope to see you again next week, same time. And please contact us if you have any questions or concerns. Thank you. Bye-bye.